Welcome to the fifth session on peaceful settlement of disputes. I will cover lots of grounds in this presentation, from the problems of lack of representation of legal traditions of the world among the judges of the International Court of Justice to the different manners in which states can bring a case before this court and its limitations. As always, I will illustrate the explanations with some leading cases, including Georgia versus Russia, Democratic Republic of Congo against Uganda, Rwanda, and Burundi, or the Gambia versus Myanmar, among many others. So far, we have covered the main diplomatic means that states use to resolve their disputes, and I have explained the differences between those mechanisms and the so-called legal means of resolving disputes, that is, arbitration and judicial adjudication. In the latest session, I addressed arbitration. There are other international tribunals, but now we are going to focus on the International Court of Justice. The explanations in this session are divided in three parts. First, I will address the composition of the court and then its jurisdiction and its role over contentious cases and advisory proceedings. I will end with a reflection about the use of advisory proceedings to circumvent the necessary consent of states to bring interstate disputes before the court, as it has been highlighted in the context of the cases on the declaration of independence of Kosovo, the construction of a wall in the occupied Arab territories, or more recently the Chagos case confronting Mauritius and the United Kingdom. So if you think about the organigram of the United Nations organization, a UN Charter created this organization, establishing 6 original bodies, which are known as the principal or main organs of the United Nations. Five remain operative since the Trusteeship Council ceased operations in 1994. As you can see, the International Court of Justice is one of these 5 principal organs of the United Nations. The ICJ statute was adopted as an annex of the United Nations Charter. It provides the main rules governing the functioning of the court. The International Court of Justice consists of 15 judges that are elected for 9-year terms by the General Assembly and the Security Council. The judges are independent and they are selected regardless of their nationality. However, this is in theory, because the statute also demands that the court as a whole represents the different legal traditions of the world. In practice, the courts, to obey this mandate, its composition has mirrored the composition of the United Nations Security Council. So, it is therefore perhaps important to remind you about the composition of the Security Council to illustrate the composition of the International Court of Justice and how they mirror each other. The Security Council is composed of 15 states. 5 of them are permanently represented and 10 are elected. By the end of January 2021, in addition of the 5 permanent members, the elected members were Niger, Tunisia, South Africa for the African group, Dominican Republic and Saint Vincent and the Grenadines for the group of Latin American countries and the Caribbean, Indonesia and Vietnam as members of the group of the Asian and the Pacific states, Estonia for the Eastern European group, and Belgium and Germany for the Western European and other states group. Considering the composition of the 5 permanent members, this means that the Security Council geographical distribution is as follows. You have 3 African states, 2 Latin American and the Caribbean states, 3 Asian and the Pacific states, and 5 Western European and other states. As I said, This model was informally reflected in the nationality of the judges of the International Court of Justice as a matter of tradition, even if it's not written anywhere and not required. This changed in 2017 when the United Kingdom lost its seat by not securing the required votes. So now, the United Kingdom is not represented among the nationalities of the judges, and there is one African national more than it has been the norm. The lack of diversity that characterizes everyday life is also reflected in who are those acting as third parties in the settlement of disputes. For instance, the members of the Permanent Court of Arbitration continue to be 90% male. I made some comments on the former lesson about the problem of diversity, or better say, the lack of among arbitral tribunals. The International Court of Justice has only recently elected women. So far, only 4 women have been judges of the International Court of Justice. The 3 current ones from the United States, China, and Uganda, plus Rosalind Higgins, whose photograph you can see here, and she was the first woman to ever occupy a seat at the International Court of Justice in 2006. If 50% of the population has been totally absent from the International Court of Justice bench and the males with Western passports overrepresented, the truth is that the range of other nationalities from Asian, African, Latin American, and Eastern European countries often hide a much more uniform background than what is apparent at first sight. If you go to the website of the International Court of Justice and have a look at the CVs of the judges, you will discover that most of them have studied or developed their careers in Western countries. This lack of diversity goes well beyond the judges. I invite you to have a look too at the names of the lawyers who have acted on behalf of the state parties in state proceedings. You will discover that the same names are repeated many times, and that independently of the country, they tend to be white male from the same states. For instance, James Crawford has been counsel in 23 cases before the International Court of Justice. A member of the Permanent Court of Arbitration, he appears also in the photo from the website I used in the former lecture, and he's now a judge of the International Court of Justice. Of course, this is never, and please don't read it like this, the result of the behavior of specific individuals. It just reflects structural problems that promote certain profiles, preventing others to ever reach these positions. But at the end, this obviously has an impact on how representative of the legal traditions of the world the International Court of Justice really is. Of course, changing structures is always complicated, and there are some signs of very slow development in terms of bigger diversity and representation of women and other backgrounds that hopefully will gather speed. However, it is important to remember that transparency and acknowledging that the problem exists is the first step. I have brought here a very, what I consider a good example on how things can actually change if we acknowledge there is a problem and we are willing to do so. So in November 2017, 2 researchers at the International Institute for Sustainable Development, Nathalie Bernasconi-Osterwalder and Martin Dietrich Brock, published a report with the title, Is Moonlight a Problem? In this report, they revealed that at least 7 judges sitting at the International Court of Justice at the time of publishing this report, plus other 13 former judges, had worked as arbitrators in treaty-based investor-state dispute settlement cases during their term at the International Court of Justice. I am reproducing here the figure summarizing the data the researchers compiled that demonstrated that the International Court of Justice judges had sat as arbitrators in 10% of all non-investment treaty cases during their tenure. Bear in mind that not all investment disputes are based on treaties or public, so this is a rough estimation. Apart from the problems of conflict of interest or time stolen from what is meant to be a full-time job, and which is more than well paid, at the International Court of Justice, this data underlines how serious the lack of diversity is. The same judges are the same people from the same sex and from the same countries that are also resolving a disproportionate amount of cases in disputes between states and in investment disputes. The issue, as highlighted by Marie Davoise in a post on EJL Talk in November 2018, is not news. However, on this occasion, highlighting it resulted in some changes, and in October 2018, the judges of the International Court of Justice announced they would not normally accept to participate in international arbitration, in particular in investor-state arbitration or in commercial arbitration. Let's move now to the role played by the International Court of Justice. So we have seen some issues about its composition and who are the people who decide and become judges, and now we are going to look at how it operates. The range of cases the tribunal can know about is known as jurisdiction. In the case of International Court of Justice, it has jurisdiction or competencies to know about two different categories of cases. First of all, it can resolve disputes between states and only between states. That's what we call its contentious jurisdiction. And second, it can resolve legal questions that are raised by organs of international organizations that have been authorized to this effect. We are going to start examining the contentious jurisdiction. Because states are totally free to decide how to resolve their disputes as an attribute of their sovereignty, and they cannot be brought before any settlement of dispute mechanism without their consent, we need to prove that the states have consented to go to the International Court of Justice before another state can take a case against them. This can be done in several ways, both before the dispute starts and after it has been the dispute arises. So before the dispute, this can be done through general declarations, what we call compromissory clause, or a special agreement. States can make declarations accepting the jurisdiction of the International Court of Justice according to the provisions of Article 36(2) of the Statute of the International Court of Justice. This, in principle, means they accept that any other states can take a case against them before the International Court of Justice. In practice, this is really limited, first because only 74 states have made that declaration, and two, because they tend to accept the jurisdiction of the court, but with many conditions. We can see with the specific examples that are provided in the website of the International Court of Justice. So if we look, for instance, at the United Kingdom Declaration accepting the jurisdiction of the court for disputes, we will see that it only accepts that jurisdiction for those disputes that happen after the 1st of January 1987, and it excludes those that may happen with another country member, either current country member or former country member of the Commonwealth, among other conditions. We have looked into the Chagos case in a former lecture. We have referred to that case in several occasions. In that context, when Mauritius wanted to bring the UK before the International Court of Justice over the Chagos archipelago, it could not, because Mauritius also has a similar set of conditions. So the dispute, first of all, was born way before 1987, and both states are members of the Commonwealth. I will get back to this again. The question here is that even if both states had made that declaration, in practice they couldn't bring. You see how it couldn't serve as basis of jurisdiction for a dispute between them. States can also accept the jurisdiction of the court through what we call a compromissory clause. Again, you can find a list of relevant treaties that are relevant to this on the website of the International Court of Justice. A compromissory clause is a provision within a treaty that establishes that disputes over that treaty can be brought before the International Court of Justice. Therefore, states parties to that treaty will be bound by these provisions, and therefore they will have consented to the jurisdiction of the court only as far as it concerns the scope of that article. Remember here our lessons on reservations to treaties. States not only must be bound by the treaty where the compromissory clause exists, they should also not have entered a reservation excluding that particular article where the compromissory clause is inserted. As I said, many treaties contain such clauses, and you can find a list of them on the website of the International Court of Justice. The limitations with a compromissory clause is that the International Court of Justice can only know about the case as far as the scope of the compromissory clause allows it, and only in reference to the treaty where this compromissory clause is inserted. So, as it has happened, states can use these clauses to bring another state before the International Court of Justice in relation to disputes that have a very loose or indirect relationship with the main topic of contention. I have discussed in a former video the case of Georgia versus Russia that was brought before the International Court of Justice on the basis of Article 22 of the Convention on the Elimination of Racial Discrimination. The protracted conflict between Russia and Georgia has very little to do with racial discrimination and much more with the use of armed force and the laws of occupation. But Georgia could only rely on this particular article of the Convention on the Elimination of Racial Discrimination. At the end, the International Court of Justice decided it had no jurisdiction and didn't enter to know about the merits of the case. A similar situation was presented to the court in the context of what has been called the Great War of Africa, which has been the second deadliest armed conflict after Second World War, with quite a few countries from Africa involved. In particular, the Democratic Republic of Congo brought a case before the court in relation to Rwanda, Uganda, and Burundi. Only the DRC, the Democratic Republic of Congo, and Uganda had made a declaration based on Article 36(2) of the Statute of the Court, accepting in general the jurisdiction of the court. And finally, that case went ahead, and the International Court of Justice issued a judgment in December 2005. In the case of Burundi, an agreement between the parties resulted on discontinuing this case. And with relation to Rwanda, the Democratic Republic of Congo tried to base the jurisdiction of the court on different compromissory clauses that were included, among others, in the Convention on the Elimination of Racial Discrimination, again, the Convention Against Torture, and the Convention of the Elimination of Discrimination Against Women. The truth in this case is that Rwanda had entered reservations to those specific treaties, establishing that in case of a dispute between state parties of those conventions, they agreed to bring the dispute before the International Court of Justice. Therefore, the International Court of Justice declined its jurisdiction. The case was interesting because the DRC also tried to make the case that several declarations of Rwanda promising to withdraw these reservations were unilateral acts of states with binding effect for Rwanda, and therefore the reservations were not anymore existing. The International Court of Justice didn't accept that argument and declared that reservations can only be withdrawn as established by treaties. However, you can see here how a conflict that related to many more states and not only to the specific states of Rwanda and Uganda, the Democratic Republic of Congo and Uganda, at the end the court could only resolve partially the issue, looking only partially at a much bigger conflict. This kind of fragmented resolution of conflicts may actually crystallize rather than resolve a dispute. We have also introduced the case of the Gambia and Myanmar. I have also repeated to you that Professor William Chagos has a couple of videos that I have uploaded to you about this particular case. But for what matters here, the case implies that the court must decide whether the alleged violation of international law that the Gambia alleges have been and that alleges that Myanmar has committed are or are not genocide. If they are not, then the court has no jurisdiction, because the basis of jurisdiction is a compromissory clause included in the Convention of the Prevention and Punishment of Genocide, in particular Article 9. I will get back to this case in a minute to examine other issues that it raises in terms of erga omnes obligations and the possibility of bringing a case before the court when a state cannot be considered directly harmed by the violations of international law of another state. States can also consent to the jurisdiction of the court either before or after the dispute by what we call a special agreement. So the states can sign an agreement by which they decide to bring a case to the dispute. We have seen several examples in which states have decided to bring a case through this kind of agreement. For instance, in the so many times already mentioned Gabcikovo-Nagymaros case, or the dispute between Qatar and Bahrain over maritime delimitation between the two states. So finally, we only have to look at the possibility of accepting the jurisdiction of the court through what is called forum prorogatum. That is, again, a Latin expression that means that the International Court of Justice can know about the case if the state that has been brought before the court accepts to take part in the proceedings, even if it had not manifested its consent previously. So a state brings a case against another state that has not accepted the jurisdiction of the court in any of the possible manners outlined before. However, instead of contesting the case and saying, no, you don't have jurisdiction, it continues on participating in the proceedings, accepting implicitly the power of the court to know about the case. This has only happened once, and it was France who accepted this kind of jurisdiction on a case brought to the court against France by Djibouti. On many occasions, states will consent the jurisdiction of the court, and the court will have to look at all these possibilities on whether or not states have accepted its jurisdiction through the possible routes I have just explained. When the jurisdiction of the court is contested, the last word to decide whether or not the court can know about the case corresponds to the court itself. It is considered a general principle of international law that judicial courts and arbitral tribunals are the competent bodies to decide on their own jurisdiction. It is referred to as competence because of its German origin, but also in French as compétence de la compétence, that is the competence, the power to decide over your own power. In the context of the International Court of Justice, the competence to decide over its own jurisdiction. I have used the French expression because it sounds very sophisticated, and I have also added a totally unrelated macaron photo to add a bit of color to this presentation. I felt it was all a bit too grey. One of the most interesting cases pending before the court at the moment is one between the Gambia and Myanmar. I have referred to it many times. And again, I have also added here a thumbnail from Professor Sheiva's recording on this case, so you remember to watch these videos if you want to know more about the topic. While we are still at the preliminary stages of the proceedings before the court, it provides a good lens to learn about different topics of international law. The case will contribute to clarify the normative content of the prohibition of genocide and the concept of erga omnes obligations. It might also become a meaningful contribution to other procedural matters, such as the legal basis for third parties' intervention and the relevance of provisional measures. First of all, only if the case fits the conceptual contours of genocide, it can be decided by the court based on the compromissory clause that serves as basis for jurisdiction. If the alleged violations by Myanmar are not categorized as genocide, the court will declare it inadmissible. This will contribute further to the case law and scholarship addressing the definition of this category, the category of genocide, in international law. In addition, the case has been brought by a state, the Gambia, with no direct relationship with the violations alleged. Some of the legal issues we have explored in former lessons on the need for the existence of a dispute to bring a case before the court will be probably addressed at length in the context of this case. Most importantly, this will be the second case, apart from Belgium versus Senegal, relating to obligations erga omnes, where a state not directly suffering damage by a violation of international law of another state is examined by the court. I refer back here to the explanations on state responsibility and concept of injured state, and how all states can claim responsibility when the obligation is owed to the international community as a whole, or how every state of a particular treaty can also claim international responsibility from other states parties to that treaty, even if they are not directly connected to the violation, when an obligation is owed to all the states to that treaty, what is known as erga omnes partes obligations. In other words, erga omnes partes obligations are obligations owed by any state party to a treaty to all the other states parties to that treaty. Every other state party to that treaty can claim responsibility from the state allegedly violating one of the provisions of such a treaty. Any state committing genocide who is party of the Genocide Convention can find that other states are claiming responsibility for that crime of genocide, even if they have not a direct connection with the victims or with the territory where these actions are committed. Obligations erga omnes are obligations owed to the international community as a whole, not only within a treaty. All states can claim international responsibility for such violations. In the case of genocide, this is both an obligations erga omnes inter partes within the context of the Genocide Convention and erga omnes as obligations as a matter of customary law. Other states have also announced they will intervene in the Gambia versus Myanmar case. These states are the Netherlands and Canada. There is a discussion on whether that intervention will find its legal basis on Article 62 or Article 63 of the Court's statute. According to Article 62, a third party not directly in the dispute can intervene if they have a legal interest. That would be premised here in the idea that the violation of international law involved is erga omnes and all states have an interest to intervene. However, because the Netherlands and Canada are also parties to the Genocide Convention, the intervention can find legal basis on Article 63, which facilitates intervention of other states if they are parties to the treaty to which the dispute refers to. Netherlands and Canada, the two countries that have publicly announced they will intervene, have not specified the legal basis on which they'll seek such intervention. The International Court of Justice can order interim measures to ensure that no damage is caused to any rights under dispute. Several cases involving death penalty in the US have been brought to the International Court of Justice requesting that the court order the US not to execute persons that were concerned or involved in these cases until a final judgment was made. So obviously in cases that had to do with non-provision of consular assistance to people on the death row in the United States, if the state, in this case United States, proceeded to the execution, the damage will be irreparable. In one of those cases brought by Germany, the Lagrand case, the court confirmed that its provisional measures are binding and therefore not following them is a breach of international law that raises international responsibility. On 21st December 2020, so very recently, the International Court of Justice announced the creation of an ad hoc committee where the court can monitor with 3 judges, so 3 judges of the court will monitor the compliance with these interim measures. Bear in mind that the terminology ad hoc in United Nations jargon means temporary for a specific purpose. The court has shown reluctance issuing provisional measures. This makes sense. If the court finds at a later stage that it has no jurisdiction to deal with a case, it implicitly recognized that it had no authority to order provisional measures to start with. This is one of the issues that's also at stake in the Gambia versus Myanmar case. The court has indeed issued an order of provisional measures. However, as I have just said, one of the main issues under contention is to decide whether or not the court has jurisdiction over the case at all. The court's judgments are final and they are binding. They are not subjected to appeal, although parties can go back to the courts and request an interpretation if they are not clear about a particular point, and also states to the dispute can instigate a revision within 10 years and 6 months from the discovery of new facts which could have impacted significantly on the decision. Each decision is taken by an absolute majority. Abstentions are not allowed and individual opinions are not only allowed, but they are also publicized. As you can see if you visit the International Court of Justice website, judges seem very unable to just agree a decision without adding their individual views on many occasions. This may contribute to more sophisticated legal arguments, but also weakens the strength of the decision, specifically in relation to the state that loses the case. The United Nations Security Council can intervene to enforce a decision, but it has never done it to date. I will cover the topic of enforcement and the measures the Security Council can adopt with this end in another lecture. In practice, states tend to comply with the judgment at least partially. The logic of a case, a judicial case, means that most of the time one of the parties will win and the other one will lose, in opposition and in contrast with the spirit that informs diplomatic means of settling disputes. However, some states might end up with a negotiated settlement between them, so a court case might instigate actually a diplomatic solution. Also, the court has found sometimes that both parties have violated international law, for instance, in the Gabcikovo-Nagymaros project case. So, not always you have pure losers and winners. So, following the order of the presentation, I will now address the competence of the International Court to provide advisory opinions. With basis on Article 96 of the UN Charter, the International Court of Justice can answer to legal questions raised by the Security Council and the General Assembly, as well as other organs authorized by the General Assembly. This is not or should not is not at all an entry point for settling disputes between international organizations. Remember, only states can reach out to the International Court of Justice to settle disputes. There is no way non-state actors resolve their disputes through the International Court of Justice. However, the advisory proceedings are meant to be more of a technical competence. For instance, using this channel, the General Assembly has asked about immunities of United Nations staff that were in missions. However, through a majority of votes of the General Assembly, states have managed to bring to the court legal questions that try to be framed as technical, but actually disguise what are substantial disputes between states. When the states, this happens when the states interested in bringing the case before the International Court of Justice don't have the necessary basis for jurisdiction, but have the necessary majority in the General Assembly to raise a question before the International Court of Justice. This has been arguably the case for all the decisions I have listed below. For instance, the Western Sahara connected to a dispute involving Morocco, Spain, and Mauritania, the advisory opinion on the legality of the construction of a wall in Palestine, the legality of the independence of Kosovo, and more recently, the Chagos case related to the dispute over this archipelago between the UK and Mauritius. The International Court of Justice has not accepted the arguments made by a significant number of states against asserting its jurisdiction over these cases, and it has instead delivered advisory opinions that have quite a leverage in the evolving situation, because advisory opinions are contrary to judgment, not binding. However, they have proven to have quite a lot of weight in how particular disputes evolve over time. However, it seems to me, and this is a personal opinion, that overdoing advisory opinion and using them as a way of circumventing the necessary consent of the state will sooner or later undermine the authority of the International Court of Justice. This has been a long presentation and also quite a black one, a gray one, because I had all kinds of technical problems, but I hope it was at least clear and you have enjoyed it.